Hey class, I was assigned the Fifth Amendment for this week's discussion and PowerPoint presentation. Forgive me if I keep looking down. I don't have a computer screen in front of me to be able to read off my PowerPoint, as I can't have my phone in my office, but I have a printout right here of my presentation. So, with the Fifth Amendment, defined from Collins & Collins' website is that under the Fifth Amendment, a person must be given Miranda warnings, including informing the suspect of their right to an attorney before a custodial interrogation by a government agent. If an individual is not warned or his or her Miranda rights, any information gained through an interrogation is inadmissible in court. So basically what that means, and aside from spontaneous utterance, when somebody's, just talking and you're not asking them any questions, you must advise individuals of their rights before you ask any direct questions that may incriminate them in a crime. This is obviously covered in the Bill of Rights under the Fifth Amendment, and there are some requirements of the Fifth Amendment. So if you are under the Fifth Amendment, you are given the right to a speedy trial. What that means is that it can't be dragged out, it can't be prolonged over extreme amount of time. You are given that right to a speedy trial and a fair jury. You can't be charged twice in two different court circuits. I'll use the military as an example. We are under Article 31 of the Uniform Code of Military Justice, which is what our rights would be as far as if we got charged with a crime. It's basically your Fifth Amendment rights, essentially. If we get charged for drinking and driving by State Patrol, our units cannot charge us with drinking and driving. We can be issued paperwork and disciplinary action. However, we cannot be charged under the UCMJ under Article 113 of driving under the influence. It also protects against unlawful self-incrimination. I mentioned spontaneous utterance before. This happens a lot of times with alcohol-related incidents where people just start talking when you're not asking them any questions. You can read them a cleansing statement. You advise them of their Fifth Amendment rights, and if they decide to lawyer up, you don't ask them any questions. If they say they want to answer questions, you ask them questions as far as how much they've been drinking, were they driving the vehicle, etc., etc. Some Miranda warning steps. So it's pretty simple with Miranda rights. Most officers read them directly off of a card. You have to advise the suspect of their rights in regards to the Fifth Amendment. Ensure that they understand that they have the right to remain silent. That is, say nothing at all. They don't have to speak to you. They have to advise their rights, and that's about it. Anything that they say can be used against them in a court of law, meaning if you read them their rights, they acknowledge, and they start answering questions, that can be used against them. They can't say, oh, no, I didn't say that. Most of the time it's going to be on body cam or in a sworn affidavit from the officer saying, this is what they said after I read them their rights. Individuals who are suspected of a crime have the right to an attorney, whether they pay for their own attorney or they get a state-appointed defender free of charge. So basically, they're not going to go in unrepresented unless they decide that they don't want any representation, and they're going to self-represent. But most of the time, they have at least a state defense attorney there that is going to, advocate for them or try to get them the most fair sentence that they feel is necessary. And like I said before, although individuals must acknowledge their Miranda rights, they can also stop talking at any time. So if they feel the need to stop talking and that they want to make sure that they are within their rights, they can consult an attorney and tell the police officer that they don't want to talk anymore. Some remedies for defense. Police officers can be cross-examined in regards to the Fifth Amendment. The defense can cross-examine a police officer and ask them questions as far as how they handled the situation. It helps the defense attorney gain insight into the prosecution side of things. And then any information gained, and if they prove that the Fifth Amendment has been violated, they can make a motion to dismiss the case and dismiss all charges. In a nutshell, the Fifth Amendment is designed to protect you and, advocate for you in a courtroom setting. And it protects you from self-incrimination. This concludes my speech or topic on week 3, discussion 2. I hope you found what I had to say insightful and enjoyable, and I hope you have a good night. Thanks.